What's up, guys? Brian Fell Law Group PLLC here with the Florida Law Weekly Case Update. This week I only got two cases for you, but they're both pretty interesting. The first one is very important, very interesting, could have potential Florida Supreme Court implications, certified conflict, and everything. It's a paternity case, and it involves donation of sperm and what rights does a sperm donor have after he donates his sperm. Has to do with the statute that's 742.14, and it says that the donor of any egg, sperm, or pre-embryo other than the commissioning couple or a father who has executed a pre-planned adoption agreement shall relinquish all maternal or paternal rights and obligations with respect to the donation or the resulting children. So what happened in this case, there was a sperm donor who must have been friends with a lesbian couple. The sperm donor donates the sperm. One of the mother basically uses his sperm at home. This isn't through an IVF clinic or anything like that. This is an at-home method. Artificially inseminates herself using that guy's sperm, and then later on she has the baby. She ends up breaking up with her partner, and the sperm donor files a paternity suit trying to establish paternity. And so he's saying, hey, I have rights to this child. Well, that statute clearly prohibits him from having any rights to the child. But the question is, does it apply when you're using some sort of at-home method like this, like where you use sort of like a syringe? The mom uses a syringe, and it's not like you're at a fertility clinic or something like that. So this is a case out of the second DCA. It's Rivera versus Salas. And so they certified conflict with a fifth DCA opinion that's kind of reached a different result. In the fifth DCA case, it was a couple that they weren't actually romantically together. They weren't married, a man and a woman, but they wanted to raise a child together. So what the man did, same thing. They used an at-home method, probably some sort of syringe or something like that, and not an IVF clinic or anything like that. It was an actual at-home method. And so they, in the fifth DCA case, they wanted to actually establish paternity. The two of them wanted to establish paternity. They were in agreement with doing that. But the trial court dismissed the case. Sua sponte said, no, you don't have any rights under the paternity statute because you gave up those rights as a sperm donor. And so the fifth DCA reversed and said, actually, that 742.14 statute that I read earlier, that only applies when you're donating sperm basically in a facility, in like in a laboratory setting. It doesn't apply when somebody's just doing one of these at-home methods. And the fifth DCA case was basically saying, well, taking to the logical extreme, any sort of donation of sperm from a man to a woman, in any sort of setting at home, that could be considered, well, I'm relinquishing my rights to the child because I'm donating my sperm. So you really got to be careful. So anyway, the second DCA in the most recent case, Rivera, they disagreed with that holding, and they basically said if you're donating your sperm to somebody else and you're not part of a commissioning couple, in other words, you're not one of the persons that wants to be the parent of the child, you're giving it up so that other parents can be the parent of the child. So if you're not a part of the commissioning couple and you don't have this adoption agreement, you relinquish all rights to your sperm. So, you've got to be careful, guys, when you're donating your sperm in that way, because if you later want to be determined to be the parent, at least in the second DCA, you won't be able to. So this case is probably going to go in front of the Florida Supreme Court, and it'd be very interesting to see how the Florida Supreme Court rules on this. It's a matter of statutory interpretation and what was intended, and the history of the paternity statutes are very interesting as well, because they arose out of what was called the bastardy statutes, where someone was considered a bastard if they were born out of wedlock. And so the Florida legislature wanted to have laws about bastards and all that. And then with same-sex couples, there was a case in 2013 that had to do with the same-sex couple, a lesbian couple, and the lesbian couple, the mom donated her eggs to the other mom, and then the mom who actually had the baby with the donated eggs, she took off and left with the child, fled to Australia. And the mom who was left behind, who actually donated the eggs, at the time, she didn't have any rights because the paternity statutes refer to a mother and a father. They use those gender-specific terms, so she didn't have any rights. But the Florida Supreme Court basically ruled that that was unconstitutional to apply that to her, and gave the mom rights under the paternity statute, even though it says mother and father and not parents. So lot of really interesting issues. I think the Florida Supreme Court needs to decide this to see, when does a donor of sperm relinquish their rights to any child? Does it have to be in a laboratory setting? Does it have to be part of IVF? Or is this any sort of circumstance where you're donating your sperm, putting it in a syringe or something like that, giving it to somebody else? Do you relinquish all your rights to the child? I don't know. Let's see what the Florida Supreme Court says. So the other case is Ticktin versus Goldmintz, and this is out of the 4th DCA. It's a guardianship case, and it has to do with attorney's fees. So for those of you who do a guardianship work, this was an interesting one. It had to do with multiple bases for attorney's fees. The first one was under 1.380 for a discovery violation, and this is basically a former couple who had a special needs child, and I guess they're still fighting over it. So the mom is the guardian. She's actually not the guardian, I misspoke. She is the guardian advocate, and that's a key difference. And the father was basically taking her back to court, saying she wasn't allowing him time sharing with their disabled adult child. Bottom line is, he got hit with fees in multiple different ways by the trial court. First under 1.380 for a discovery violation, but the father said, well, I eventually complied with the discovery order, and my motion for extension of time was partially granted, so I shouldn't have to pay fees. Well, the 4th DCA said, no, the attorney for the mother was still entitled to fees under 1.380 because the attorney had to actually file a motion to compel and take it to court. So still entitled to fees under 1.380. The second basis for fees was it was a summary judgment motion under 1.510H, which allows to get fees for essentially like a fraudulent affidavit in opposition to summary judgment. And this was basically, the court didn't necessarily award entitlement to fees under that summary judgment statute, but it reserved jurisdiction. And so the 4th DCA said, okay, well, let's send it back and see if the trial court grants entitlement to fees, then you can get fees. But that was sort of more like just a technical thing, whether the court actually granted fees under the summary judgment statute. Two more statutes. 744.108 allows guardians attorney's fees for guardians. That's only in a guardianship proceedings, which is different than a guardian advocate. Guardianship is more involved. The ward has to actually be declared to have the need for an actual guardian. There's a whole process for that, different than the guardian advocate process. So in this case, the mom was only a guardian advocate. She wasn't the actual guardian, and so they couldn't get fees under 744.108. But they could get fees under 744.37152, subsection 2, which allows for fees when somebody's bringing somebody back to court, essentially in a guardian advocate case. It applies for that. When somebody's bringing them back to court because they're saying that the guardian advocate is not allowing time sharing, let's say, or access to the family members, you can get fees for that if the person who's filing that claim saying, oh, the guardian advocate's not allowing me to have access to the ward. You can get fees if a claim like that is frivolous, essentially, without merit. So they were entitled to get fees under that statute, 744.37152, subsection 2. So interesting case as far as guardianship fees. I would research that one if you're doing guardianship work to see when you can get fees. But definitely keep your eye on that Rivera versus Salas case, that paternity case and the artificial insemination case. That's going to be very, very interesting to see how the Florida Supreme Court rules on that. So I'll keep you guys posted if and when it happens. All right, guys, have a great week. Take care.